Your Lordships,
Yes.
if I may make mention of one unlisted item.
What's the urgency?
Your Ladyship had passed in the last occasion, that was on 27th. Your Ladyship, there's some issue with the service of notice. So
What happened?
Your Ladyship's the office order, the office notes, that is not in, my lords, coherence with the order. The respondent numbers to be served are different from what the order is reflecting.
Okay. List it tomorrow.
Your Honors may list it today.
Today.
Because Your Honors, tomorrow it'll be Friday and courts will be closed. Whatever directions Your Honors may give, I will be able to, my lords.
Courts are supposed to be closed. No.
Saturday onwards, my lords.
Saturday onwards.
Registry again won't accept any.
Let's see if the registry can manage or not.
Grateful.
Your Lordship, I would like to mention part 2, item number 6.
6.
Yes, Your Lordship, because the main counsel is having some personal issues. If the court has just made a...
It was listed for hearing today, isn't it?
Yes, Your Lordship.
Then what happened?
My apologies, Your Lordship, I have no further information regarding that.
So you're appearing on behalf of?
Mr. Lerem Sanghnaka, main counsel.
Who's for the respondents? Have you taken their consent?
No, Your Lordship.
Hmm?
No, Your Lordship.
Anyway, you are the appellant. Mention is made on behalf of Lerem Sanghnaka, learned counsel for the appellant, for adjournment of the matter. Accordingly, list after the ensuing vacations. Yes.
Part 1 list for admission. Item 1.
My Lord, in this case, I am standing on behalf of the respondent number 9. So I'm still waiting for the instructions, and I pray Lordship to kindly grant me at least 3 weeks for filing my affidavit in regard to the show cause.
Yes. Yes, Ms. Dinari. Mrs. Dinari Azu, learned counsel for the petitioner, is present, along with Mr. P.C. Lalthangmoya, learned counsel for respondent number 9. The learned counsel for the respondent number 9 has prayed for further time to file their show cause reply. In view of the above, list after 3 weeks.
Item 2.
May it pleases Your Lordship, the case has become infructuous as I have been issued a new LSC in pursuance to the order, my lord.
Not infructuous, but the contempt case can be closed since
Yes,
it's
my
been
lord. Yes, my
complied
lord.
with, isn't it? Heard, Miss Valentina Laldinpui, learned counsel for the petitioner, along with Miss,
HC Deborah Nanziri.
along with Miss,
HC Deborah Nanziri.
okay, H.C. Deborah Laldinpui, learned counsel for the respondents number,
2 and 4.
state respondents, is it?
Yes, my lord.
No, learned counsels appearing for respondents number 2 and 4. The learned counsel for the petitioner submits that, where's the judgment? The respondents have taken steps for issuance of land settlement certificate in the settled plot number 0777
My lord, if I may.
Yes, that's the
that-
judgment order.
That land was not allotted, a different land has been allotted to
Okay,
the,
has been issued a land settlement certificate. LSC number CAD 1718 of 2024. Which is in compliance, we'll just make it in compliance, okay, of the judgment and order of this court in WPC number 115/2021. And therefore, she submits that the instant contempt petitioner may be closed. In view of the above submissions, since the respondents have complied with the judgment and order of this court in WPC 115/2021, the instant contempt petitioner is disposed of and closed. Is closed and disposed of. Yes.
much obliged.
Item 3.
Make it is closed and stands disposed of. Okay, that language. Yes.
Lordship, in this case, the opposite party is not yet present. So far as my knowledge, they have engaged Thang Moya. Actually, in this case,
Okay, so you filed your affidavit
no.
with regards to dusty service?
Yeah, yes, yes.
Yes, so
So,
notice is deemed to be served. Anyone representing?
so they approach.
Okay, so we'll fix another date. We'll give them some time to be represented, isn't it? I heard Ms. Denari Etiyazu, learned counsel for the appellant. It is seen that a notice has been served to the respondent through dusty service, and affidavit to that effect has been filed. In view of the above, notice is deemed to be served upon the sole respondent. This is it. None appeared for the respondent. In view of the above, list the matter after the ensuing. Let's make it 3 weeks. After 3 weeks.
Lordship, one advocate informed me that he's going to present. He's going to file a vacate today, and after holiday.
Yeah, after the ensuring vacations, to enable the respondent to be duly represented. Yes.
For order. Item 4.
Yes.
Yes, my lord, this is bail application. Then the petitioner was arrested on 12th June. Then in connection with special narcotic PS case number 26 of 2024. And under section 21C, 29, 1 and 25. Then read with section 14A of the Foreigners Act. But he is a permanent resident of Bethlehem Aizol. Then section 14A of Foreigners Act is not liable for him. Then the CIS article in the present case is 2.340 kgs of suspected heroin kept in 200 soap cases with a market value of 70 lakhs and 20,000 rupees. And then, my lord, the petitioner was produced before the magistrate on 13/6/2023. Then the prosecution praised for remand for 72 period. Then during the remand period, as he is required to be brought before the medical officer, he was brought at the civil hospital Aizol. Then since he is required to be admitted at that time, uh, on page number 18 that medical officer on duty had advised him to go to ZMC Falcon Hospital as there are no beds available in civil hospital Aizawl. Then on 14 he was brought to ZMC Falcon. Then he was admitted on 15 of June. Then he has been in this hospital till date. The petitioner has a chronic liver disease. Then he has also a medical history with that liver problem. On page number 27, Dr. Benjamin Khiengte has also certified medical certificate that he is currently under treatment at my center and requires further investigation. Then on page number 29, also on 5/7/2019, at that time, that is way back in 6 years, bending was also done upon the petitioner. So since he is in hospital till date for about 20 days, he is not fit to be kept in judicial custody, then we are praying for the petitioner to be released on bail on the grounds of medical problem due to his health problem.
Yes. Oh,
And
that's it?
moreover, my lord, the seized article were not recovered from the possession of the petitioner. He has no involvement in the present case.
It was recovered from where?
From the co-accused.
That's always the case, isn't it?
Yes, yes.
Let's have, we'll have to see. Yes.
Yes, actually.
My lord, it has been stated on behalf of the petitioner that he has a chronic liver disease and liver kidney problem. However, my lord, he was admitted in the hospital on 15 June. And on 12, he was arrested. So it shows that he is fit to transport all this heroin, even though he has a chronic liver disease. So it cannot be very serious in this case, my lord. And moreover, it was the seized article was recovered from the joint possession of him and the co-accused while they were riding a bullet bike and a scooty. So, my lord, the involvement of the petitioner is clear in this case. And the rigors of 37 also applies to him, my lord, because it's a commercial quantity. So he may not be released on bail at this stage. Investigation is going on.
So where is he right now?
ZMC,
ZMC.
So he's been taken care of, isn't it?
yes, yes.
He's been looked after. He's getting all the medical treatment, and I think it will be free of cost when they are from the judicial custody. So it's all the better for him. Then after his discharge, we will see whether the jail doctor says that he's fit to be in judicial custody or not. At this stage, I don't think there are any grounds. Okay. He's being looked after in the hospital, isn't it? So I don't think he's facing any difficulty. Yes, I heard Mr. LLP Anfela Tsongtu, learned counsel for the applicant/petitioner, along with Mrs. Linda L. Pambal, learned PP for the state respondents. Now, previously, I think you had approached the,
Yes, we have approached the special court also.
yes. And here also it was on medical grounds?
Yes,
This
that time
was
also on the medical
dated
ground.
18th July. Here also the trial court had reflected that he's receiving the required treatment. This is an application filed under section 439.
Yes, 49. Read with section 37 of the NDNPS Act.
CRPC, read which is section 37 NDNPS Act for grant of bail to the accused slash petitioner who was arrested in connection with special narcotics PS case number 26 of 2024 under section 21 within brackets C slash 29 within brackets 1 slash 25 of NDNPS Act, read with section 14 of Foreigners Act. Now you're saying he's a permanent resident, but there's nothing here. No documents enclosed to show that he's a permanent resident, isn't it? NDNPS, okay, of Foreigners Act, good stop. The learned counsel for the petitioner submits that the petitioner was arrested on 12/06/2024 at Saitwal Police Station along with the co-accused Jinsian Komung of Bulfek, Myanmar on the allegation of seizing 2.340 kgs of suspected heroin kept in 200 soap cases, which is having a market value of 70,20,000 from the joint possession of the present petitioner and the co-accused. The learned counsel submits that the petitioner is innocent of the charge registered against him and that he is a permanent resident of Aizawl.
Yes.
Aizawl. He further submits that the seized article was not seized from his possession but from the co-accused. The learned counsel further submits that the petitioner may be released on bail on medical grounds since he is suffering from chronic liver disease and is presently being looked after at ZMC hospital. For the past, how many days? 20 days, for the past, since his admission into the hospital on, when was he admitted?
On 14.
On 14th June 2024. The learned counsel submits that because of his medical condition, he is not fit to be kept in judicial custody and may therefore be granted bail since the petitioner is also innocent of the charge under Section 21C in the NPS Act. Mrs. Linda L. Fumble, a new para. Mrs. Linda L. Fumble, learned PP, on the other hand, has strongly objected to the release of the petitioner on bail at this stage, submitting that the seized article is of a huge quantity and was seized from the joint possession of the accused, of the petitioner and the co-accused. She further submits that even though the petitioner is said to be suffering from chronic liver disease, he was fit enough to travel. And these seized to travel when the seized articles were seized from their joint possession. She further submits that, though you did not submit, I'll point out, she further submits that the petitioner is not a permanent resident of Aizawl and is likely to abscond if bail is granted at this stage. Having heard the submissions made by the learned counsels for both the parties, this court finds that the petitioner is being given the necessary medical treatment at ZMC hospital, and therefore thus it appears that it may not be necessary to grant him bail purely on medical grounds. It is also seen that he has been charged under Section 14 of the Foreigners Act, and therefore there could be a possibility of him absconding if granted bail at this stage. This court also finds that there is no prima facie evidence to show that the petitioner could be innocent of the charge made out against him under Section 21C and the NPS Act. For the above reasons, this court does not find any grounds to grant bail to the petitioner at this stage. Accordingly, bail application number 63 of 2024 stands dismissed and disposed of. Yes.
Item 5.
What is the stage? Oh, yes. Try and settle the matter, whether they are willing.
Yes.
Have you spoken?
Yes.
They are brothers and sisters, and they are fighting over the money left behind by one of their brothers who died. So what happened?
My lord, as per my senior instruction, my client doesn't will to settle.
Okay.
From
So
our
what is
side,
the
we are
state?
ready
Ah.
to have settlement.
You are the sister of the deceased, is it?
Yes.
And you are the brother of the deceased. Yes. Okay, then if they don't want, we cannot force them also, isn't it?
Yes.
So what is the stage?
Uh,
We'll list it in the after the ensuring vacation.
yes, my lord.
The learned heard Mr. So and so, learned counsel for the appellant, along with Mr. So and so, Remplonga, learned counsel for the respondents. The learned counsel for the appellant submits that they are not ready to have their matter. They are not willing, okay, to have the matter referred to Lok Adalat. In view of the above, list this matter after the ensuring vacation. Paper book has been prepared and furnished. Okay, so it will be for hearing.
Yes.
For hearing, yes.
Item 6.
My lord, listen.
My lord, I think in this case we have to call the LCR, my lord.
Yes, my lord, we have some problem with the issuance of notice also, my lord, because the name of the complainant is written as Mr. Y.
As?
Mr. Y.
Oh, no, my lord, actually, this is a connected appeal. So there was one other appeal which was already disposed of. And this is a connected appeal. I think we can get the names from the previous appeal that was filed, my lord. I think the previous case.
The appeal was filed by whom?
It's a jail appeal, my lord,
By the same?
by the same person.
Then?
So what has happened was, my lord, he was accused for committing two offenses under the POCSO Act. So he got convicted for these two offenses, my lord. Now, instead of preferring two separate appeals from the jail, what he had done was he had only filed one appeal,
Okay, two separate victims.
two separate victims, two
Okay,
separate
yes.
trials, but in one appeal by mistake from the jail, my lord.
Okay,
So it's a connected appeal basically in that sense. So I was the amicus in the previous case. So that's the reason why I have been retained in this case also.
Okay, in the previous case, was the appeal allowed?
No,
No.
it was dismissed.
Is he what, some school master or something? No.
He was
Teacher?
He was no, he was
Because we have some cases in Champai where there was one accused person who was a teacher and he had
no,
sexually assaulted
that is
quite a
also-
few students.
that's another case, ma'am.
Another
This is from
case.
Policy, yeah,
That's
my lord.
that's from
This is Colosseum. Okay, yes. Third, Mr. Joseph L. Rentley, learned counsel for the appellant, along with Ms. Linda L. Fumble, learned counsel, learned PP for the state respondents. It is submitted by the learned PP that notice upon respondent number 2 could not be served since the name of the informant / respondent number 2 is marked X.
Y.
Is marked Y in what?
Mr. Y. From the judgment,
Okay,
We
it's
have to
marked
call
as
LCR.
Mr. Y in the judgment?
yes, my lord.
In the judgment and order.
but in the records, my lord, his name will be there.
Yes, we'll
The
have to
records is
see
there.
the reports.
In view of the above, LCR is to be called for to verify the name of the informant in the instant case. LCR be called for, list after the ensuing vacations.
Obligement.
Oblige.
Item 7.
My lord, in this case, I'm for the respondent number 1 to 5, claimant. The appellant herein, I think they have to complete
What
the
do you,
notice.
yes, notice
In respect
who is
of,
the, now this is an IA, isn't it? So IA is for condonation of delay?
Yes.
So notice is not complete?
Notice has not yet been completed.
How
in
many
res-
days delay? Condonation is day spread for how many days?
56 days.
How many?
56.
56. But the council is not present, isn't it?
We'll have no objection on my
What,
part.
you'd have no objection. Had he appeared, we could have disposed of the instant IA at least.
I'm appearing on behalf of the council for the respondent number 6, National Insurance, my lord. Since the council is out of station, my lord, I'm appearing on
Okay.
behalf, and I may be given time to file the objection, my lord.
Oh, you want to file, huh?
My lord, if I may interject. In the meantime, if this owner
Notice has to be completed upon respondent number
3 and 4,
3 and 4. Who
Well,
are there?
the owner and the driver, they were not appearing before the learned presiding officer and message as well. So notice can be waived as per my understanding.
But the this thing has to be here, isn't it? The applicant, you don't have to. So we'll see. Anyway, none appeared for the applicant, while Mr. C. Lalfak Omar,
Zwala,
no, Zwala, appears on behalf of respondent number
1 to 5.
1 to 5. And Mr.
Benjamin,
Benjamin Lalsamwana appears on behalf of respondent number 6. The learned counsel for respondent number 6 submits that he may be given time to file their written objection. It is also seen that notice upon return of AD card from respondent number 7, is it?
Submit to. Okay.
Is still awaited. In view of the above,
They don't know.
upon 7 and 8, okay? 7 and 8 is still awaited. In view of the above, list after 3 weeks. Yes.
My lord, in the meantime, if my submission may be reflected, that I will not submit my written objection to the IA.
Okay. The learned counsel for respondent number 1 to 5 submits that they will not be filing any written objection. In view of the above, list after 3 weeks.
Right.
Item 8.
Your Lordship, further 1 week's time may kindly be granted, Lord, for filing my objection.
My lord,
Yes.
in the meantime, I will not object to my learned friend's prayer. If your lordship may allow me to replace my documents, which is at page 34 to 41. I have inadvertently annexed the case diary, wherein I should have annexed the charge sheet, since in this case, charge sheet has already been submitted.
So at the time when you filed the bail application, was the charge sheet ready?
Yes, it was ready. And even in my petition, I have mentioned that relevant pages of charge sheet is annexed herein. So there was some inadvertent mistake.
Okay, not objected?
No, my lord.
Heard Mr. C. Lalfakzola, learned counsel for the applicant, along with Mr. C. Zoram Chana, learned counsel for the learned special PP. Is it
Yes.
learned special PP for the respondents? The learned counsel, the learned special PP for the respondents have prayed for time for filing of their written objection. Mr. C. Lalfakzola, learned counsel for the applicant, submits that he may be allowed to replace page
34 to 41.
34 to 41 in his application filed, since he had mistakenly annexed the wrong documents at page 34 to
41.
41, which is the case diary, while he was supposed to have annexed the charge sheet, a copy of the charge sheet. This prayer is not objected by the learned counsel, the learned special PP for the respondents. In view of the above, the necessary corrections may be is allowed to be made in the presence, is allowed to be made, okay? Thereafter, necessary, the copies of the corrected documents is to be furnished to the learned special PP. List after 3 weeks. Yes.
Obliged.
Well, with due respect to your lordship, can it come on a fixed date?
Okay. When do you want it?
19th of July?
19th of July. Is it 3 weeks, or should we make it less?
Because it's not the first time my learned friend has prayed for that time.
Okay. Anyway, it's 3 weeks. List on 19th,
My lord.
7, 2024.
Deeply
Yes.
obliged.
Item 9.
To make the necessary corrections / replacement.
Your Lordship, this is bail
application subsequently filed after the earlier bail application was rejected by the Special Court Lunglei District. My lord, I'm filing under section 37, read with 439 CRPC and section 37 of NDNPS Act. And
Okay, we'll issue notice first,
yes, my
isn't
lord.
it? I heard Mr. Bila Ramena, learned counsel for the applicant, who has filed the instant application under section 439 CRPC, read with section 37 of the NDNPS Act for enlargement of the accused/petitioner on bail. The learned counsel submits that the petitioner was arrested on when was he arrested?
9/11/2022.
9/11/2022 for the alleged possession of what?
1.747 kgs of suspected heroin.
1.747
kgs.
Okay, yes, I see it here. 1.747 kgs of suspected heroin. And a case under case Lunglei PS number 163 dated 09/11/2022 was registered against him under section 21C/29 NDNPS Act. Full stop. Issue notice to the respondents, Ms. Linda L. Fumble, learned PP, accepts notice on behalf of the state respondents. Requisite copies of the bail application, extra copies of the bail application to be duly furnished to the learned PP. List after the ensuring vacations. Yes.
My lord, if it may be fixed on 22nd of July. That is after vacation.
Yes, will you be prepared by then? 22nd, 7/2024. Yes.
July.
22nd.
Yes,
Immediately after the vacations, that is, yes.
My lord, when you pass that order that extra copy be furnished.
Yes, I'll
It's
pass.
always the registry who furnish extra copies, so I think we'll have to make it clear. It's a burden for them. Extra burden for them. They are always supplying us an extra copy.
So it is for the bail applicant?
Yes.
So I've mentioned.
Yes, the registry
So do
always
the-
supply us extra copies. So it's extra burden for the registry.
So in the order, it is that the extra copies is to be due by, do you want me to add by the applicant?
Yes, my lord. That will be-
That's how it should be.
Yes, it should be like that, but these days, my lord, we are always receiving extra copies from the registry. So that is why I want to mention it.
If it is a case which is filed from the jail or something, then it's a different matter. Otherwise, the applicant will make extra copies, isn't it? So I think it's clear. Okay, extra copies or to be duly furnished to the learned PP by the applicant. Yes.
My lord, it may be taken up on the fixed date because I'm going to be out of station.
I thought we mentioned
22nd of July.
We have mentioned
Yes.
the list on 22nd. Yes.
Much obliged.
Item 10.
Yes.
May I please, Your
condemnation.
Lordship, I'll be appearing on behalf of the respondent and I'll,
How many respondents? One?
yes, only one.
Yes.
And if I may be allowed, I'll be submitting my power after vacation.
Okay. Miss
Lalompuy Panay.
Lalompuy Fanay, learned counsel for the applicant is present, while Mr.
Zodin Priyanamte.
Zodin Puyanamte submits, learned counsel submits that he will be appearing on behalf of the sole respondent and will be filing his wakalatnama shortly. In view of the above, list after the ensuring vacations. Yes.
Much obliged.
Unlisted case, writ petition 11 of 2024.
Yes. What is this about?
Your Honors would recall, your leaderships may recall that this case was regarding that MPSC discrepancies
Yes,
in the written exams.
So, in view of the above, learned counsel for the is allowed to serve fresh notice
Yes.
upon the above mentioned respondents through registered post with AD Yes, so what happened?
Your Leaderships, what had happened was, your Leaderships had passed this order on 27th.
Huh.
Before that, Honorable Justice Kaushik had passed the orders on 31st of May.
Huh.
Your Leaderships, that order has created some confusion now because as per the office note, the writ petition is to be served on, the numbers are different basically, Your Honors. The private respondent numbers are different.
Okay, let's see.
Yes.
Here we have mentioned 4, 7, 8, 9, 16 as per the order.
Yes.
When you had appeared, you
Yes,
had
yes.
said it should be the same numbers.
Yes, yes, Your Honors.
Then what happened?
Your Honors, it was definitely a fault on my side also that these numbers were actually for the IA. There's one IA pending.
Okay.
Yes.
So what are the numbers?
Your Honors, the numbers reflecting on this, on the last order, this is supposed to be for respondents in the IA.
Okay, so in the WPC?
In the WPC, Your Honors, those numbers, Your Honors, I have created a small note. Those numbers, there are around 17 respondents who still need to be served.
So what are the numbers?
6,
6,
7,
7,
8,
8,
10,
uh,
11, 16,
Just
19,
note down the numbers, okay? 19,
20, 21, 25, 26, 27, 29, 31, 32, 33, and 34. Your Honors, insofar, your Leaderships, insofar as IA is concerned, 2 respondents also need to be added as per instructions from registry, as in for service.
Okay, besides what was
Yes,
mentioned.
yes.
Okay,
Correct.
now let's finish with WPC first, okay? Matter is put up today. Heard Mr. Jordan Robinthanga, learned counsel for the petitioner, who submits that the notice to be issued to the respondents as per this court's order dated 27/06/2024 needs to be modified since the respondents in the order dated respondents in the order dated 27/06/2024 should actually be respondents number, then those numbers. Okay, just repeat the numbers.
Yes, yes. Your Leaderships, if I may give this.
Yes,
note.
give the list.
Your
Should be so and so. In view of the above, the learned counsel for the petitioner is to serve notice upon the mentioned respondents instead of the respondents mentioned in the order of this court dated 27/06/2024.
Your Leaderships, if I may just interject. I'm so sorry, Your Leaderships, but
What?
Your Leaderships, I must humbly pray. Ultimately, I'll be bound by Your Lordship's decision. But Your Honors, this matter has been pending and it can be disposed of given that counter has come from the other side. Your Leaderships, if I may be able to serve them through newspaper publications. These are all private respondents who have become officers. They will definitely be circulated with newspaper. They are already at
But where they're posted?
Your Leaderships, this I will circulate through a state Pan Mizoram newspaper publication. Probably that is Wanglaini, as I've been informed. This will be circulated throughout Mizoram. So wherever they might be posted, Your Honors, given that they are officers, they most probably will be having this. They would be adequately informed here. Or else, Your Leaderships, the problem which has now occurred of Your Leaderships postal receipts not being able to track, and so forth. This may again repeat, and Your Leaderships writ petition may suffer because of that.
See, because if you look at the previous note,
Yes.
postal receipt does not show their tracking numbers due
Yes.
to misprint.
Yes.
So, will there be a misprint the second time?
Your Honors, of course,
don't think
nobody
so.
can guarantee that.
Because this is some mistake which had occurred once. Okay?
Yes, yes.
And main reason is due to some misprint.
Yes.
And they was also unable to print another copy. So it's not necessary that the next time there will also be another misprint.
Your Honors, I'll be bound by your Lordship's decision.
You see,
I'm only suggesting.
misprint happens only once in a while. Otherwise, it's not every time that the misprint will happen,
I bound.
isn't it? So, you see, newspaper, because we really don't know where they're all posted. And simply saying, if it will be more troublesome for you to file newspaper publication, if we say that it should be also published in the local newspapers where they are staying.
Yes.
You see, because in each district, I think they have some local newspaper. That will be more troublesome for you. You
As
see,
Your Honors
you
direct.
have these local little newspapers also in each
Correct,
district. Okay. You see, simply presuming that Wanglaini will reach all the districts and especially where they could be posted, which could be in some far-flung village also. Do you
Yes,
know
yes.
where they are posted?
Your Honors, that information we don't.
That's why, no? And then they could have the plea. I didn't see the Wanglaini, I didn't know about it. Simply presuming that they'll read the newspaper. I think it's a bit, okay, the numbers you give, okay? In the true registered post with AD, within 5 days, returnable by 3 weeks, yes. List after 3 weeks. Then in the IA, same. What is in the IA?
Your Honors, apart from the respondents which were reflected in the last order,
Yes.
just 2 more respondents have to be served. 25 and 26 have to be added. I'll just pass on this note.
Okay. Now here, wait. Here it is not as if notice has to be served. In the IA, the last order is has prayed for further time to file their rejoinder affidavit.
Yes.
So
Your
it
Honors,
appears
even-
that notice is complete.
No, Your Honors. The office note was not reflected in when the matter was taken up on 31st May. That's why the confusion.
Yes, on the 31st, the order was that you had prayed for time to file your rejoinder affidavit. So same order was passed.
Yes.
Because you had prayed for further time, isn't it? Yes, anyway, today's matter is put up. Heard Mr. Jordan Rumingthang, our learned counsel for the applicants, who submits that notice upon the respondents is not complete in the instant IA and prayed that he may be allowed to serve fresh notice upon the respondent's number. So now I'm referring back to the order of this court dated 25/04/2024. Wait, is may be allowed to serve fresh notice upon respondent's number, okay, 4789 16 20 21 23 31 32 33 34 36.
Yes. And,
And
20,
yes.
office note I've included, I think 25 and 26, I believe.
Okay, 21 23, after that 25 26, okay, then 31 32 33 34 and 36. Praise aloud the learned counsel for the applicant to serve notice upon so and so. Okay, the mentioned respondents through registered post with AD within 5 days, returnable by 3 weeks. Just
Extremely
after
grateful,
3 weeks.
extremely.
Yes.
For hearing, Part 2, Item 10.
Yes.
Your Worship, I'm appearing on behalf of my senior. My senior, Mr. Lal Fakoma, is having some personal difficulties.
You had prayed that this matter be listed today, isn't it?
Yes, but can the
What
matter
happened?
be listed out? He's having some personal difficulties.
Mention is made on behalf of Mr. Al-Fakoma, learned counsel for the appellant for adjournment of the matter since he is not able to appear due to some personal problems. in view of the above, just after 3 weeks. Yes.
Let's go.